The views expressed by our guests are their own and do not reflect the official stance of their employer or any affiliated organizations. Welcome back to the Council House Podcast. I'm your co-host, Daniel Abramoff, and today I've got a special interview with Managing Associate General Counsel over at Verizon, Karan Singh. Today, we're going to be discussing the CFPB's reinterpretation of old laws and how they affect different areas of business, the different challenges, and maybe different tips that one could take. Karan, thank you so much for joining us.
Yeah, glad to be here.
So maybe you can break down for our audience what these new reinterpretations from the CFPB mean and how they affect different areas of business now that the different laws that are coming into place on May 22nd, actually, and what they might mean towards businesses like yours.
Sure. Before I start, I just had to point out that I'm here representing myself. I'm not representing my employer. I'm just a guy who was happy to come on and just talk about how these reinterpretations and new regulations that are being issued will affect businesses in general. I can't speak exactly for what we're doing at Verizon, but I can just talk to you generally about what I've heard other colleagues in the industry writ large in the legal field may have been telling me, and also my own personal thoughts.
Absolutely.
Sure. So the CFPB has been very aggressive under the current director, Rohit Chopra, in terms of both bringing enforcement actions and issuing reinterpretations of old rules and also issuing new rules, which are greatly expanding the scope of the CFPB's authority and also trying to basically send the message to industry that they are watching you and they are looking for anything that they perceive as a consumer harm that they're going to identify through these reinterpretations or new rulemakings and stomp them out because they really take their mission seriously of protecting consumers. And that's what all these actions are geared towards in their minds, is helping consumers.
Sure. And so one of them comes into place and is the buy now, pay later, a rule that effectively came in and is saying that if an organization is taking payment more than once, it is going to be considered a credit card. Mm-hmm. And so what are your thoughts on that?
Sure. So that's a perfect example of the CFPB reinterpreting an old rule or old law in a way to apply to what it perceives as risks in the marketplace today. And so under this reinterpretation of a longstanding rule that was issued under the Truth in Lending Act, the CFPB's position now is that in certain cases, if you have an online account that you're using to basically administer your different individual buy now, pay later loans, if you want to call them a loan, that online account, which is used to manage these different loans, is the equivalent under the law as a credit card. Right? Most people may hear that and say, well, how does an online account equal a credit card? And the CFPB went through this exhaustive kind of tortured, to be honest, analysis to come out and say, well, we think the existing definition of a credit card can be applied to this situation here. And as I was saying earlier, their goal is to bring protections to what they see as a gap in the regulatory regime concerning lending products and credit cards and these buy now, pay later products. And so what they're doing is filling this gap in by saying, look, under the existing law, if you do certain things, then you meet the definition of a credit card. And one of the definitions that they've kind of honed in on is a way to go back to the well, so to speak, to draw more cash, in this case, for a buy now, pay later loan. And so they're saying, well, by going back to this online account, which you set up with one of these many online buy now, pay later companies, that's kind of like a credit card, right? Because you're going back to the well, so to speak, to get more credit to buy more stuff. And in their minds, that seems to look like a credit card to them.
Yeah. Well, it sounds like at a certain point, a lot of things could probably be considered a credit card. So I could see how that type of change in the rules can leave many different departments in a confusion and not really knowing what to do. Do you feel that the CFPB is putting out sufficient guidance on these reinterpretations and how is there, how these businesses are able to comply with it, and is there is there uncertainty with everything going on?
Sure. So there's definitely uncertainty if you're outside of the buy now, pay later space with how the CFPB is going to apply this new perspective to other laws. Because when you take a step back and look and see who the CFPB can bring enforcement actions against. It's very clearly spelled out in the Dodd-Frank Act. You're either a provider or offerer of a consumer or financial product or service, and there's like quotes I'm going to put around there because there's a laundry list of 15 different types of products or services that are literally like spelled out, like issuing loans, right? So issuing credit or extending credit is one of the listed elements. There's debt collection, that's another one, and then it keeps going, right? And then that's how they can get you. But if you don't fit within that laundry list, there's also this other authority the CFPB has to enforce different statutes. And so there's a laundry list of statutes that are also in Dodd-Frank that the CFPB can enforce or has enforcement authority. It used to be kind of split between the Federal Trade Commission, maybe the Federal Reserve, DOJ. And so some of these laws were gathered up in Dodd-Frank, and it was spelled out. CFPB, you get to be the main enforcement authority for these laws. And one of them is the Truth in Lending Act, which they share jurisdiction with the Federal Trade Commission. And so if you don't meet that laundry list of consumer financial products or services, then you would think you're scot-free in a way where the CFPB doesn't have jurisdiction over you.
Right.
But if you're covered by the Truth in Lending Act because of something you're doing, well, now they can get you, right? Like George Costanza, just when you think you're out, they pull you back in, right? And so you may think as a business, I'm not offering a credit card, I'm not offering credit the way people think of credit, like a car loan. You're just a business out there letting your customers buy stuff from you, and maybe they pay you back next month. You send them a bill, right? And that's the classic example of a business. And the CFPB's statute, Dodd-Frank, has an exclusion for businesses that's colloquially known as the merchant exclusion. Because if you're a merchant selling your own goods or services that are non-financial in nature, then you're generally excluded from the CFPB authority, because I guess there was a lot of paranoia when Dodd-Frank was getting drafted that the CFPB is going to kind of go wild across all kinds of industries. And so the language in the statute of CFPB or the Dodd-Frank Act said CFPB only has certain jurisdiction over certain conduct. And so in this case, if you're a business who meets this merchant exclusion because you're selling widgets or whatnot to people, and you think, well, I don't have to worry about the CFPB because I'm not doing that other stuff and I fit within this merchant exclusion, but the CFPB's kind of got this trump card, right? It's like an Uno reverse card where it says, sorry, you're covered by these other laws, so we can come and enforce those laws against you.
Wow.
And so this could be a way to extend their jurisdiction,
Sure,
potentially over businesses that don't think they're even in the consumer finance market. But lo and behold, if you extend the reasoning, like we were saying earlier about this buy now, pay later reinterpretation, suddenly all these other businesses may come into the scope of the CFPB's authority, but they didn't really think they were because they're not offering what they think of as a consumer financial product or service. And
so much so that it sounds like they can even go sort of back in time to have companies account for certain time periods and certain revenue streams that they've brought in. So it's not, across the board, whether you're a small business or a large corporation, it sounds like there's going to have to be a lot of education around what that means for them.
Sure, potentially, because that's where some of the uncertainty comes up is now, if you're kind of watching this buy now, pay later reinterpretation play out, as a business, you're probably wondering, well, gosh, what do I have that I'm offering my customers in a way that kind of looks like that thing over there that they're pursuing? Am I going to be next, right? That's what businesses out there are thinking is like, well, could it be me that comes up? Because if they take that reasoning, they don't need to issue a whole other regulation to extend it. They can just investigate you and say, you kind of look like this other thing that we publicly stated. And so we think you're covered by it. And unless you're going to fight them in court to prevail and say, no, Dodd-Frank was clear, we're not covered by you, you're more likely to just settle. And in that case, there's no track record that other companies can look at to say, well, no, that doesn't apply.
Right.
But the CFPB can say, well, when they settle, they admitted jurisdiction, right? Because in their settlements, it states that you, as the settling party, don't agree with anything really other than the fact they had jurisdiction over you. And so if you settle because you want the enforcement action to go away because they have very stiff penalties, which I'll get to in a second, then they can point to that and say, well, look, so-and-so, they agreed you're doing the same thing and they settled, and that sends a signal out to the marketplace. And the reason I point out the penalties is because they're pretty severe. So a violation of one of these enumerated consumer financial statutes, has its own little penalty provision. But if you violate those provisions willfully, right, the CFPB's got this staggered set of enforcement penalties. And so if you violate a known statute, then potentially they could start assessing civil penalties on you.
That is something else. And that is going to be, I think, just moving forward, a big part of a legal department's challenge towards understanding how to really protect their company when dealing with this type of stuff. Lately we saw some different things that went through the Supreme Court that pretty much allowed them to put a lot of limits on administrative agencies and what they can do. Mm-hmm. How do you see this affecting the regulatory frameworks across the industries?
Right now, there's a lot of uncertainty, right? That's like the theme of this podcast is regulatory uncertainty. But at the same time, there's also hope, right? Because there's hope that some of the rules or reinterpretations or even the rules and rulemakings that have come out from all kinds of different agencies will get a second look. And you don't have the deference is the word I was thinking of here that courts would give necessarily to agency reinterpretations or rulemaking justifications that they may have put out in the past. And now the courts kind of take a second look at it. And so the hope comes up that maybe you'll convince a court somewhere to see things your way as an industry participant, that maybe you think the rule was overbearing or just wrong for different reasons. And now instead of just sort of shrugging and taking your lumps, you have a chance to maybe get the rule recognized judicially to being not valid.
Yeah. Giving businesses the opportunity to have a second look at something is huge. And as much as I, along with most Americans, agree that a lot of these agencies are doing the best work for our country, I do think that sometimes when things get passed through really quickly, mm-hmm. and it can have some really detrimental effects on things, to be able to re-examine things, I think is exactly what the founders of this country probably wanted. Nothing to be passed through without truly passing it through, all eyes on, and understanding the negative and positive effects of it.
Sure, and I have an example for you. So the CFPB put out a rule recently, a final rule that's known colloquially as the open banking rule, right? So finance nerds like me know it as the 1033 rule, right? 1033 is the section of Dodd-Frank that said the CFPB must put out a rule to permit consumers to obtain information on the financial accounts held by one of these financial service or product providers, right? And so it sounded pretty good in Dodd-Frank, but what the CFPB had done was take that language and they really ran with it. And in their proposed rule, which they put out, it wasn't just letting people get access to their financial records held by their banks or their lenders or their credit card issuers. It was, okay, the CFPB's position was, yeah, you're going to let these people get access to their records, but we're also going to let those people share those records with third parties. And that, to me, right, reading the 1033 section of Dodd-Frank and then reading the proposed rule, I was thinking, well, how did they get there, right? And so what I learned over time was that as the CFPB director went out and kind of went on the road show to kind of explain, his reasoning, he thought, well, Dodd-Frank lets consumers get access to their information, right? Which kind of seems like what 1033 says, but in his vision, getting access to your information must be for a purpose, and the purpose would be to potentially find better products that could meet your needs rather than the products you're getting or the services you're getting from your current provider. And you should be able to take your records, right, as getting access to them, and port them to someone else if they could do a better job for you. And so the proposed rule said that anyone who has these records has to build a portal, right? We call it an API, an application programming interface, that would allow these third parties to plug in to your systems electronically on the internet to vacuum up these customer records.
Wow.
And that was done in the rulemaking to allow what they call open banking. So 1033 has gone now from letting customers see what records the businesses have on them, right? Like what your bank has on you or what your credit card issuer has, to now letting you take those records and do what's called open banking, which lets you switch providers much more easily, which is a laudable goal, I think.
Yeah.
Right? But did 1033 really say that? And so a bunch of us were kind of watching this proposed rule play out. And then when the final rule was issued recently, I think it may have been last week, the time this podcast is going out. I think the rule went out last week. Like literally the morning the final rule was announced, that afternoon, one of the industry associations had already filed a lawsuit to challenge it, basically on the same reasoning that I just laid out, that 1033 was only really envisioned to allow customers to access their own data. And this third-party data sharing really seemed to be way outside the scope of the law.
Sure.
And then, there are issues that were raised in the lawsuit about data security and how do you keep just some random crank from coming in off the internet and claiming that you gave them permission to get access to their bank records. And so the CFPB did put out in a series of other like supplemental rulemakings before the final rule was issued, information on how to protect that data and how to authenticate that third party really was an authorized third party and not just some crank, like I was saying. So they were able to give some guidance for that part of the rule.
And that allowed all the different banks and organizations to put that in place, which effectively protected from that. And looking at how other countries, including our own, are focused on data privacy and data protection, that obviously is huge.
Right. The one of the goals of this open banking was to match, at least as the CFPB has been articulating, is to kind of match or mirror what's happening in Europe, where there is an actual law that says you have to have open banking, processes in place if you're offering European residents these financial products. And so Chopra's thought was, well, they're doing a pretty cool thing over there in Europe, so we should turbocharge competition here by bringing open banking to the forefront. But it gets back to the question, well, what did Dodd-Frank say? Did Congress really intend open banking to come to the U.S. when they passed Section 1033 back in like 2010, right when Dodd-Frank was made it out of Congress? I personally don't think so. I think the courts are going to have to answer that, which is what the lawsuit is hoping to get some clarity on. But it's an example of how industry is not just taking it lying down. They're striking back now that they have more opportunity to challenge some of these rules and the reasoning behind the rules.
Right. And of course, going back to the fact that the Supreme Court is now going to be getting involved even more, I think that adds some weight to both sides. Do you think that regulatory upheaval will lead to more compliance risks for companies, or could it present new opportunities for growth and innovation?
I think it's a mixed bag of both, but if you had to see which one's going to win, I think it's going to be the opportunity for growth and innovation. And that's because of how the existing laws can be read to be a straitjacket in a way. And if the companies have a creative argument for why they can escape the straitjacket, then they should generally go for it, right? If it's going to be bringing a product that could be great, something new to the marketplace, you don't want to stifle that, because we have other laws in place today to protect consumers. So you have the basic Dodd-Frank Act. You've got the Federal Trade Commission Act, which prohibits unfair or deceptive acts or practices. You've got many state FTC acts, which pretty much every state out there has a law that says you cannot offer a product or service that's unfair or deceptive, or have a process that's unfair or deceptive towards consumers. And so there are ways to police bad apples out in the marketplace without putting these new and frankly unduly needed restrictions on the industry.
So with the buy now, pay later change in rules, how would that hinder companies from being able to bring new products into the marketplace?
Sure. So, for example, with the buy now, pay later rule and the way it's considered a credit card. So as a credit card, under these credit card rules that the CFPB says now extends to the buy now, pay later space, there are certain requirements that you as a credit card issuer have to meet, right, to issue the credit cards. And some of them are pre-opening disclosures. There's potentially, depending on how far you extend this rule, potentially issues with crediting the payments when the payments come in for the product. There's also existing state laws in many cases that kind of cover this area, but these credit card rules will just sort of layer onto that. And so as a new entrant to the marketplace, say you want to get into the space of small dollar lending to consumers, so you generally have to abide by the state laws that you're in, which require disclosures. They require those unfair or deceptive protections I mentioned before. And so now as a credit card issuer, you'll have to issue potentially like monthly statements. You'll have to deal with the accounting issues I mentioned before. There's certain dispute resolution rights that you'll have as a credit card holder that you don't necessarily have as a loan holder. But in some ways, the new rule would be redundant, where you'd have to build something twice to cover both the state lending rules and this now federal requirement, when the state laws probably could have been sufficient to protect the consumers. And so what are you really getting? Like, what is a marginal benefit, so to speak, from these credit card protections that the existing laws didn't cover? It's kind of a hard question to answer. And so as an entrant, right, as a fintech company trying to get into the space, now you got to come up with processes to comply with these rules that you probably didn't need to before. And now you got to figure out how to pay for that, right? Because as a business, you're trying to make a profit. And every time you have a compliance requirement, that just builds incremental cost in and potentially slows down your ability to innovate.
Yeah, absolutely. And thinking about a company who might get into business making some product that, obviously has nothing to do with credit cards or finance,
right?
They now have to focus on building out a little mini financial company. Is that right?
Yeah, they would.
Wow.
Like things like monthly statements, like is a business selling widgets. You just care about the customer coming in and then you get delivery out the door, right? But now you have to provide these customers with a monthly statement just because they set up, when you go to a website and, there's a bazillion websites that say, okay, you can set up an account and like track your order, that sort of thing. So those companies would now have to issue like monthly statements potentially.
Yeah. And if their customer decides to put a hold on their credit card or they decide to reverse a charge, I can see how that also could be somewhat of a frustrating thing where now you're going to have to probably put up that capital, to be able to back these expenses. So it is very fascinating because I think obviously we're going to see a lot of changes coming into the fold. Do you feel that there are going to be a lot of changes within the next couple of years, or will it take time for these to really go into effect?
I think the changes from the Supreme Court's decisions will probably go into effect pretty quickly because the pace of the court challenges seems to be increasing just reading the industry news over the last few months. And so I think it'll speed up.
Shifting topics, we were talking about work-life balance and self-care, and as an attorney, it becomes it's an ever-longing challenge to be able to constantly keep up with all the different matters that are coming in, making sure that you're always ready to go, you're up to bat, while also taking care of a family and yourself. We talked about different types of tips that you took on through maybe some more uphill battles in your career. How have you managed to reassess and kind of create a better work-life balance after going through different types of experiences like that?
Sure. So it's a topic that's kind of near and dear to my heart because I have a history of different medical issues with my family, right? I'm trying to avoid having those problems like diabetes and heart disease. And so one of the big things you can do to prevent diabetes and heart disease is to kind of reduce your stress. And so one of the things that I found through trial and error really is setting boundaries. And I know it's not necessarily easy for everyone to get into that mindset depending on where they are in their career, but you need to have a plan in a way to set some boundaries about when you're not going to answer an email, when it's going to be time for you to stop doing whatever you're doing to maybe go for a run or go to the gym. Because the number one thing you got to take care of is your health, because without the health, you're no good to your employer, you're no good to anyone, you're no good to your family.
Exactly. I completely agree. And that is, not to say that I'm copying you, but that's exactly what I chose to do. And the more I run, the more I feel my mind is sort of free to continue to go work.
Sure.
So that's the irony. You're taking a little bit of time away from work so that you can go and be prepared to do more,
Yeah, that's definitely true. Like in a way, it may seem like a cost. Like there's like different ways to look at your expenditure of time. And so there's like a time benefit reward or a time reward benefit, however you want to characterize it, where the 20 minutes or 30 minutes you spend going for a run could increase your productivity, right? To look at it from maybe an employer's perspective, your productivity for the rest of the day may be increased because if maybe you didn't go for the run, you kind of get into that afternoon slump and then you're like no good for anyone because then you're going to get coffee to try to stay awake. And that doesn't help you concentrate because now your mind's racing.
Yeah.
And so there's different ways you can frame your need to go take a break in a way that your employer can appreciate, because if you show them the benefits of you being able to kind of tune the engine, so to speak, then you get better horsepower performance. And I found that to be helpful.
What advice do you have for young legal professionals and on how to maintain their well-being while pursuing such a demanding career path?
Mm-hmm. Sure, that's a great question, and it's going to be a very nuanced answer that I'm going to give, because I remember when I first started working, I was at the Federal Trade Commission as my first employer, and I was very fortunate to, number one, have a really supportive leadership in my division that was very into fitness and self-care, and so they were able to really give me that space to go take a little bit longer lunch and go for the run on the mall, right? And so I was fortunate to have that background, but I know not everyone has that. They may be stuck at a law firm or something, or maybe their boss is not so reasonable. And so all I could offer that person in that situation where they're stuck at a law firm and they can't go for a long lunch because they have to bill certain hours is just kind of micro planning is the way I call it, where you break up your day into maybe 20 or 30-minute chunks, and you're just going to have to be really organized to say, okay, so I got to bill X number of hours today. But that will leave X amount of free time or Y amount of free time. And then I can build that free time in throughout the day and chunk it so that maybe you take an hour now, but you're going to put in like whatever the time is for billing a little bit later, but at least you have a plan so that you come in for the day and you say, okay, this is what the plan's going to be for the day. And, sometimes the plans can change, but at least you have a plan, right? So I was in the Marine Corps, and there's a saying that no plan survives contact with the enemy. And it's kind of like something that could come up during the day where you think you have your schedule laid out, which happens to me now, but lo and behold, one email comes in and blows up your daily schedule.
That's right.
But at least you had a schedule to
right.
work
At least
from.
you had the plan.
Right.
That's not to always bring up this quote because it's overly used all the time, but everyone has a plan until they get punched in the face. And that's the Mike Tyson quote, which is
very similar.
But I like what you're saying is you got to always be prepared so that just in case you don't get that email that rocks everything, you'll be able to break it all up. And then over time, the more you practice something, the more it just becomes muscle memory and you just do it.
Sure.
Yeah.
And one thing that's new now that wasn't out there when I was starting off was that there's this issue of like the micro exercise, where back in the day it was like, well, you got to get the 45 minutes in of exercise. But now research has shown that you don't need to do 45 minutes in a block. You can chunk it up to 10 minutes, 4 times a day, and you get almost as much benefit, right? So that would be maybe taking the stairs, walking to the metro right afterwards, maybe doing push-ups with the office door closed, right? Depending on how people in the office may perceive you doing push-ups, right? And so that could be in between calls. You like knock out these little micro bursts of exercise, but by the end of the day, you've got the sets down that you didn't think of at the time, right?
And you feel good. You're going to naturally be in better shape, and you're going to probably get your work done and still just not be wiped out from the day.
Exactly.
Yeah.
So you did get a workout in, even though you didn't go to the gym. You were able to come up with alternatives.
It's very important. It's very important to let your brain breathe, especially in the environment that you're working in. And I think this has been very, very incredible advice to have, going back to the different changes in regulatory changes in these rules and your opinion on it all the way through to mental health, fitness. Mm-hmm. I really am super grateful to have you as a guest, and
thank you so much.
And looking forward to sharing this with our audience and having you back for another interview soon.
Sure. We'd love it.
Thanks.